versus the South Neighborhood Association. And I see we have the attorneys here present. Good, I guess it's still good morning. Good morning, Mr. Collins, and good morning, Ms. Norse, and welcome to the virtual oral argument. Just a reminder for both of you that whoever makes the argument to please unmute your microphone, and the other person, and I see Ms. Norse, you already have yours muted, which is excellent. And the appellant, Mr. Collins, you could request up to 5 minutes for rebuttal. And I do have my little timer right here. Whenever you're ready, sir, you may proceed.
Good morning, Your Honors. May it please the court, Bill Collins on behalf of appellants BKHI Slips LLC and Brian Seeger. I'll reserve 4 minutes, Your Honor, for rebuttal.
Very good, sir.
As Your Honors are aware, this case involves basically the interpretation of a Marina Declaration and to possibly a lesser extent, also the interpretation of some other declarations that have been filed. And I'm going to try to keep the background short, but just so everybody's aware, this concerns Harbor Island. And in 1985, Harbor Island, the Master Declaration was filed and recorded, which set up basically the development plan for Harbor Island. In 1993, and in that declaration, in the very preamble of the Master Declaration, it says the developer is the owner of certain real property located in Hillsborough County, Florida, known as Harbor Island. And then it has a defined term, the island or the property. And then if you go to Exhibit B in the Master Declaration, it shows that, again, it defines the island in Exhibit B, and it says that part of a parcel of land bounded by Seddon, Garrison, and Sparkman channels. So Harbor Island has three sides, like a triangle. It's got a channel on each side. And then if you even go to Exhibit F in the Master Deck, there's a sketch of what Harbor Island is, and it includes all of that property that's explained in Exhibit B. We move forward to 1993, and the Marina Declaration is filed by the developer, and that's in order to set up the Harbor Island Marina Association and to administer the marina that's going to be built there. And the only place in all of the documents that describe or define who an owner of a marina slip can be is found in that Marina Declaration. And in sections 9.1 and 9.2, it makes it very clear that the owner is limited to persons or entities who also own residential property on Harbor Island other than rental apartments. And it uses. Can
you walk me through something? And I'm not sure if it's not on the record, don't tell me, but just as a kind of a point of getting me referenced here. Yes. When a slip is transferred, is there like a recorded deed that gets transferred like you would for a closing?
Your Honor, yes. These there are deeds and they're recorded in the official record, so it's like a piece of property. These slips.
Got it. So the idea here is that we're almost talking about miniature little lots. They just happen to be on submerged land.
I think that's correct, Your Honor. Yes.
Okay.
At least that's correct in my mind, Your Honor. I will by no means make myself out to be an expert on marina law. So as I was saying, so in sections 9.1 and 9.2 of the Marina Declaration, that's the only place anywhere that states what the requirements are for an owner of a marina slip. So then we fast forward a number of years to 1999. There's some random amendments made to the Master Deck and the Marina Deck, and there's a Marina Water Walk created. And the Marina Water Walk is going to give access to any Harbor Island residents to the marina. And then it also says we're going to create these three different neighborhoods now, the Southern District, the Northern neighborhood, and the Piazza neighborhood, I believe. And then in 2002, the Southern Neighborhood Association declaration is recorded. So here, what I have is Mr. Carney or Mr. Carney's company, BKHI Slips LLC, entered into a contract in 2016 to sell slip number 13 to Mr. Seeger. And it was undisputed Mr. Seeger was a resident, owned real property on Harbor Island. So what happened was the SNA, the Southern Neighborhood Association, filed suit to enjoin that sale, basically under the argument that you have to reside in the Southern Neighborhood District in order to own a slip. It went to a summary judgment hearing. The Harbor Island Marina Association, who's actually charged with administrating the marina, was of the same opinion we were, that the documents were clear, that all you had to do was be a resident or own real property on Harbor Island, that there wasn't this additional restriction you had to live behind the gates in Southern Neighborhood Association.
Here's Mr. Collins, but wouldn't you agree, and looking at the record here, what the court has done in reaching its conclusion, didn't look at all of the documents, not just, when you're going to be interpreting the definition, or if you're going to be interpreting what does this mean, shouldn't you be looking at the whole document as a whole, and then to make sure that whatever definition will be consistent throughout?
Well, Your Honor, you're correct. And if you look through the whole Marina Declaration, other than sections 9.1 and 9.2, you're not going to find anything about anything contrary to you have to own real property on Harbor Island. What the court did, and I'd like to get to that because it's interesting how the hearing unfolded, because from the very beginning, the argument was, at least from our side, look, Harbor Island is unambiguous. It is what it is. And you don't have to go any further. You apply common, sensible interpretation to what Harbor Island is. And unless that's unclear, you don't have to take that other step and all of a sudden take parole evidence, start looking at a declaration that was filed 9 years later, and not even look at the master declaration that preceded it, which very clearly defined what Harbor Island was as far as the developer was concerned. So that's kind of the first issue I want to talk about, because Judge Cook, she goes in the order, she goes right into, okay, I need to interpret what this phrase means, owning residential property on Harbor Island. She never even gets to that first point of whether she should interpret that, whether it's necessary to interpret that. Is it unambiguous? Is it ambiguous? She just kind of skips that step altogether, and she starts taking parole evidence and letters from 2013 and how the SNA has interpreted it. And it's kind of a bizarre. So our argument would be the term Harbor Island, it's a piece of land. It is what it is. Nothing has changed to Harbor Island. What Harbor Island was in 1985 is what Harbor Island was in 1993. It is what Harbor Island was in 2002, and it is what Harbor Island is in 2020. So I would argue, and the position of appellants is that it was unambiguous, and that ended the conversation or the analysis, at least it should have. But then the trial court then skipped another step, because if you say, well, I think Harbor Island is ambiguous, I'm not sure what they mean by that, then there's you have to determine, is it a patent ambiguity or a latent ambiguity? And I would argue, in the position of the appellants, is that at the most, if Harbor Island is an unclear term, at the most it's a patent ambiguity, because like I said, nothing has occurred from 1993 to 2002 to 2016 to now to change what Harbor Island is.
Well, I think what your friend on the other side would say is that, well, there has been some change. Now, whether or not it's appropriate to consider any of this is a separate question, but sure, there's been some changes. Harbor Island got developed, and in the course of development, it created new neighborhood associations, and it put up big walls, and it made some of those, gradually concentric exclusive enclaves within Harbor Island. And pertinent here, some of those neighborhood associations got charged with picking up the fee, the common expense for the marina walkway, et cetera. I think that's what your friend on the other side would say.
Well, I'm sure it is, Your Honor. But I would say that you're right. It got subdivided into 3 neighborhoods. But all these documents were amended in 1999. the SNA was filed in 2002. No one ever said, whoa, 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 we gotta redefine Harbor Island. We no longer mean the entire island, which is exactly what the definition is in the master deck. Whoa, wait, now we got to change it because we're gonna cordon it off. So now a marina slip owner has to live, it has to be part of or own residence in the Southern Neighborhood Association. Nothing was ever done on that. Nothing was ever amended. Nothing was ever put into any record showing that that distinction all of a sudden changed. Because you're right, it developed and everything else. They could have easily said, okay, now Harbor Island, now it needs to be subdivided or subdefined as different neighborhoods. But that never.
Well, I think what the argument would be more pertinent to how you interpret not necessarily the original 1985 deck, but the 1993 Marina deck. And sections 9.1, 9.2, which is to say, look, the only people that are carrying the freight here are the people in the Southern Neighborhood Association, and therefore it's proper that the benefits only, any potential benefits of slip ownership ought to be limited to those who would necessarily pay those.
Well, in your honor, and obviously you have to look at that. So 1993, you have to see what the intent was in 1993.
Mm-hmm.
SNA wasn't even a figment of anybody's imagination, as far as I can tell, in 1993. So
well, that goes to an interesting point. Does by virtue of ownership of a marina slip, are you subject to assessment?
To the marina, if you own a slip, yes. Yeah. Nobody.
Doesn't that answer the inquiry about benefits and costs being divorced? No, instead it's whoever owns the slip. By qua ownership of the slip, you are subject to assessment. Is that correct?
Well, maybe there's a distinction I'm missing here. Obviously, you pay to the HEMA or to the Harbor Island Marina Association fees for the slips, and then there are some common areas that are now behind the gate that SNA pays for, and that was done in the SNA declaration. But we're not talking excessive fees, Your Honor. We're talking about some grass, a gate. But if you have a boat slip, you don't get that boat slip for free. You pay fees to the marina for your boat slip. So it's not, no one's getting a windfall. And that's what I find kind of ironic a little bit from Judge Cook's finding to that. We're talking very minimal expenses. Well, first of all, nothing was put in the record as to the amount of the expenses. But to the extent everybody has access that lives on Harbor Island to the harbor, to the water walk. And that was another, and I'm kind of getting beyond because now I'm going into the parole evidence as was it proper, et cetera. So, but I'll go back to the argument that, first of all, I don't think Judge Cook needed to get to where she got to because I think it's unambiguous by the documents. Second of all, she never explained why it was a latent ambiguity. And she clearly went into parole evidence. And once she went into parole evidence, you had a situation where you had the plaintiff saying there was one interpretation, and then two separate defendants saying there are two different interpretations. You had the very entity that manages the marina saying, whoa, wait, no, SNA can't do that. The only thing that we're controlled by is the declaration from 1993. And we clearly have to allow that sale. And in their motion for summary judgment, the marina's motion for summary judgment, they attach all the documentation. In their very first documentation is their checklist. And this is 2016. Their checklist for if you can buy a slip. And it says property owner of Harbor Island. So even the marina was under the impression as long as you owned real property on Harbor Island, you could buy a slip. And there's been a lot of, the appellees make a big deal about Mr. Sampson at the hearing saying this is a summary judgment hearing, Your Honor. It's subject to summary judgment, no problem at all. To be fair, I think to the appellants and Mr. Sampson, I think when he was saying that, he was talking about this term Harbor Island is an unambiguous term, and therefore Your Honor can resolve this on summary judgment. I think once Judge Cook started taking parole evidence, she clearly took into account everything the appellees put into the record, but she didn't take into account the master declaration, the documents provided by HEMA, by HEMA, the Harbor Island Marina Association. And we had a verified motions for summary judgment ourselves that said, no, Mr. Seeger would have access to the marina because he has access to the water walk. And that might be a problem if you have to lug stuff by walking down a sidewalk? Possibly, but it was kind of not really to the point yet. So I guess basically, all in all, we're basically, to just kind of repeat myself, I think we missed a couple steps in the analysis. There was no finding of whether it was ambiguous or not. There was no finding of whether it was a patent or latent ambiguity, no explanation of how it was a latent ambiguity. And then all of a sudden, Judge Cook started taking parole evidence and using a document that was 9 years after the Marina Amendment and started trying to read those in conjunction, even though that 9 year later SNA declaration nowhere discusses anything about ownership of slips. Yes, it talks about some fees. This is what SNA is going to be responsible for. They're going to have to keep the grass in front of the marina, everything else. But nothing to the point of like, oh gosh, okay, because we're going to have these expenses, now we're going to limit everything to SNA members. And I think the record also shows this didn't become an issue until 2013. And that was when my client started buying several slips. And
Mr.
all of a sudden,
if I may, Mr. Khan, you're about to go into your 4-minute rebuttal. So if you'd like to conclude right now and save the rest for rebuttal, or you're ready to proceed.
I'll proceed, Your Honor. I appreciate that. In Appley's own summary judgment motion, one of their exhibits is a letter from 2013 or an email chain. And it's clear that this is the first time this is becoming an issue because all of a sudden, Mr. Carney and his entities own more than one slip. And people don't like that fact. So now all of a sudden, instead of going back and amending the documents, which they have every power to do, they're trying to now have a court go in and tell everybody what the developer who's passed away thought Harbor Island was in 1993, and that the developer thought Harbor Island was the Southern Neighborhood Association, even though the Southern Neighborhood Association didn't even exist for an additional 9 years. And I think we're on summary judgment. We're in contractual interpretation. The review is de novo, as I don't have to tell Your Honors. And I think Judge Cook just kind of went a step too far by ignoring the plain language of the contract and then ignoring any contradictory evidence in the record. And I know opposing counsel is going to say, well, Mr. Sampson said that it was 100% undisputed facts. Well, even if Mr. Sampson intended to say we have no other argument if you find it's not unambiguous, that still doesn't relieve the court of applying the proper standard to her summary judgment order and making sure that there wasn't even a scintilla of contradictory evidence in the record. And with that, Your Honors, I guess I'll reserve whatever I might have left. Thank you so much.
Very good. So you actually have 2 minutes left, Mr. Khan.
Thank you.
So if I could trouble you to mute your, excellent. Ms. Norse, you may proceed, ma'am.
Good morning, Your Honors. May it please the court. My name is Kristen Norse, and together with Stuart Markman of Kynes, Markman, and Fellman, we represent the South Neighborhood Association. BKHI's argument on appeal really seeks to pluck this one phrase from the Marina Declaration and to interpret only that phrase in isolation and now without regard to either the text of the whole Marina Declaration or the text of the other 3 interrelated documents that govern the entirety of the Harbor Island development. And the trial court rejected that approach. She had to interpret that phrase in context of all of the documents to look at what the developer's expressed intent was. And the developer's expressed intent was clear. In context, the intent was to restrict slip ownership to the secured limited access area in which the marina was located, and then to roll the marina into a neighborhood district that would have exclusive access to it, exclusive rights to it, and would be exclusively required to pay for it. And so what the trial judge was looking at was some interpretation that reconciled those documents and made them consistent, harmonized them, versus BKHI's interpretation. And BKHI's interpretation subverted the developer's express intent. It would have expanded slip ownership to persons who had no obligation to pay for the marina common area, who had no right of access over the private roads in which it was located, and would have no
to be clear, they would have access by the marina walkway, correct? They could walk there.
Well, that depends again on how you interpret the amended and supplemental declaration, because the only access to the Marina Water Walk that you would have is if you interpret the Marina Declaration as giving access to the water walk to a slip owner who is not a homeowner. And even then, it's only the pedestrian access. And when you look at the documents themselves, when you look at the Marina Declaration itself, it says you're going to need access over roads, you're going to need adequate parking, you're going to have issues of security. So the very reason stated for this restriction is that road access, and you just can't get around that. And so all of that is undermined then by BKHI's interpretation.
Help me out, because was the phrase owner of Harbor Island other than rental units, was that ambiguous?
In context, yes. In context, because—
Hold on, well, because I see what you're trying to do. What you're trying to say is when you read the whole thing as a whole, it becomes ambiguous. The problem is it's kind of a chicken or the egg thing a little bit. Usually the whole imprimatur only comes in when you identify the ambiguity first, then you start looking at the whole, okay, obviously this doesn't make sense, this term. I need to look at how the whole thing fits together in order to come to an understanding. And we said that in our Barrett v. Liar case. We say, if it is necessary to construe a somewhat ambiguous term, the intent of the parties as to the evil sought to be avoided expressed by the covenants as a whole will be determinative. It's a first this, then that kind of. So work with me on this hypothetical, if you would, please, without going to the whole context. Is the phrase owner of Harbor Island owner in Harbor Island, is that within, whether it's 9.1, 9.2, is that ambiguous in any way?
If you interpret it in isolation and facially,
yes,
which the law says you're not supposed to do, and I'll explain why.
We said in Barrett v. Lair, we said you do it that way.
Right. No, so what the law says on the declarations in particular is that the declarations have to be read in context, both historical context and the context of the document. And yes.
And in all of those cases, it was determined there was an ambiguity, right?
And I don't think that the result is any different if you determine that because if there's an ambiguity here, it's a latent ambiguity. But I don't think there's an ambiguity when you look at all of the documents together. And that is also required by the law. The law consistently says you have to look at the interlocking documents. So I want to turn really quickly.
So you're not willing to say that the term owner of Harbor within 9.2, just the phrase that you're looking at, that you are not telling me that is ambiguous.
I do think it's ambiguous.
Okay.
But I think you want me to say, I guess I'm feeling like you want me to say it's ambiguous if I'm just looking at those words. And I don't think you can look at those words without the context in which they're written. I don't think that the law allows that, particularly when the words right above it say the reason for the restriction. If the reason for the restriction was ownership versus rentership, then the reason for the restriction would read something like owners are more likely to care for the property and be better slip owners. But what it said is we're placing this marina in an area of limited access. And then I also want to point out that part of this that has been overlooked by BKHI and its—
But Harbor Island itself is something of a limited access community, is it not?
Not north of the gates. Those are public roads. That's what the records reflected. At the time this Marina Declaration was created, the only area that was restricted private roads and continues to be is that south neighborhood portion. And I want to point to the Master Declaration because as BKHI acknowledges, the Master Declaration is the superseding declaration, right? And the Master Declaration has a very important point as to why you can't look at this Marina Declaration in isolation. Because the Master Declaration says specifically, we are going to create neighborhood service districts. That's the setup of the island. And when you own in a neighborhood service district, then the intent under the Master Declaration is that you will share expenses for your common areas and the neighborhoods will be entitled to the services or rights of use which are not enjoyed by all members. Had the Marina Declaration stayed as a standalone marina, then we might have a different issue here. But then, consistent with what the master declaration said was the developer's intent, in 1999, we do the amended and supplemental declaration. That amends the Marina Declaration, it amends the master declaration, and it does exactly what the master declaration says it's going to do. It creates a South Neighborhood District and rolls the marina into it. So I don't think you can look at the Marina Declaration in this one phrase without looking at the developer's overall intent in the Supreme Master
But yeah, I see that development actually cutting against you, because if anything, at the time all of that occurs, everyone is aware of what the restriction is. The restriction is if you can only have one of these slips if you're an owner on Harbor Island. If you're going to create that kind of exclusivity, that's the time to do it, to say henceforward no more. From now on, owners of the slips shall be only those behind the gates of the southern neighborhood. But they didn't do that.
Well, again, and that's why the law says you have to look at this in the historical context, because in the historical context,
If there's an ambiguity.
Once they rolled it into the South Neighborhood District, then you're now under the Master Declaration. And the Master Declaration, in fact, says assessments for a neighborhood district must be used exclusively to promote the health, safety, and welfare of members of that district. So all of this is a common thread in which the Master Declaration says we're going to create neighborhood service districts. It happens that the marina is created before those are created, but then the developer goes back and rolls the marina into the South Neighborhood District. And only the South Neighborhood District is assessed for the common areas. I want to talk about that a little bit because I think there may be, it's a fine point, but I think it's an important one. The marina consists of marina common property and marina limited common property. So as a slip owner, you are assessed for the limited common property, which is like the finger piers, the boxes, the electricity that's adjoining your slip. The marina common property is the seawall and the water walk. It is a significant expense. There was record evidence of it, about $80,000 to maintain that. And it is exclusively the expense of the South Neighborhood District residents. And that also shows the developer's intent, because in the Master Declaration, assessments will be in a neighborhood district for the people who have exclusive access. In the Marina Declaration, we're doing this because of the exclusive access. That's the reason for the restriction. Then you have the Amendment and Supplemental Declaration, which recognizes slip owners are already a subset of unit owners. There are no unit owners on the north of the gate. So they are only going to be assessed as unit owners. You cannot assess them separately under the Amended and Supplemental Declaration because they are recognized as a subset. And then you have the South Neighborhood Declaration, which does exactly what the Master Declaration, the Amended and Supplemental Declaration says it will do, which is the South Neighborhood District is responsible for this and has exclusive access to it.
Ms. Norris, can you take up an issue? Mr. Collins wasn't able to get to it, but it's his third issue on appeal, and that's the I'll tell you, it's kind of since these slips are, you make the argument that they are, well, I guess I'll let you make your argument that they're not like real property that is conveyed and subject to the terms of real property conveyances. But if they are, this seems like an extraordinary limitation on their alienability. You've basically taken real property and said, you know, at first you had a universe of potential buyers that was limited to an island. Now you've said, no. Now it's limited. The only people that can ever buy this property are people who live on the southern part of this island. Can you address that argument and that concern?
Yes. So I agree there's no case law that says that this type of land interest, and I said it's akin to riparian rights. You know, they're the submerged lands next to a plot that is above land. And so there are historical restrictions that have been on that kind of an interest.
Yeah, I've never heard of people transferring, buying and selling riparian rights ripped free from the underlying situs to which those riparian rights pertain. I've just not heard of that before.
Right. And so I think you have to look at it in that context of this is a historical.
Well, I say that because I don't think I can. I'm not sure that what they're buying and selling here are, you know, inchoate riparian rights, and that they're for. I don't think you can do that. Mm-hmm. I think it's more likely what's being transferred here is interest in defined land, albeit submerged land. Submerged land can be transferred. I mean, it happens. So how do you deal with the inalienability issue here?
Right. Well, in order to find an unreasonable alienation, you have to show basically that that in context, it's unreasonable, it's unalienable. There is no case on a submerged lands or that kind of property right that holds that this would be, as a matter of law, such a extreme restriction that it would ruin your marketability. And in fact, the evidence in the record was that these slips are marketable. There was over 600 neighborhood residents behind the gate. There's 87 slips. All of the slips were privately owned. A third of them had changed hands in the past 3 years. And indeed, BKHI itself had bought up 12 of the slips, clearly not concerned about the marketability or the ability to use them to benefit South neighborhood residents. So there just was no showing that this was a type of extreme restriction that had to be, set aside as a matter of law. Quite the contrary, there was no case that would have supported that.
I mean, it seems to me that if the argument that you're making that it's just the intent, and it was always the intent, that the slips should only stay within the part of the neighborhood that was then developed at the time they were made, which was the southern part, which turned out to be, that what the developer would have done is just made those slips a part of the real property description of a particular lot. And so you get it with a lot or you get it with a unit, and that's it. But instead, it seems like the intent here was, no, we got a chance to create some new property here, get it out into the market, and generate some revenue from this. Let's do it.
I disagree for a couple of reasons.
Okay.
The first is that I don't know how you can say that and then without reading and then reading the reason for the restriction, because the Marina Declaration says the reason for the restriction is because the access to the marina is limited to this area, and it's for adequacy of parking, accessibility, security reasons. And so to say that they meant to then open this up to everyone on the island in a way that they hadn't even anticipated at the time as a marketability thing runs afoul of that. And then again, looking at the master declaration, when you roll it into a neighborhood district, then it's an amenity, a self-funded amenity for that district. I think.
Would there be anything preventing, the South? The complaint that you're raising is that, look, the folks in the South Neighborhood Association are getting tagged with the seawall, right. The marine owners. Would there be anything preventing them from saying, look, you don't have the right to use our roads or to park here, but if you want to, well, you slip owner that resides outside of the South Neighborhood Association, if you want to use our roads and have the security and all that, instead of having to schlep all your stuff, through the sidewalk, we'll charge you. Would there be anything preventing them from doing that?
Yes, the
What?
amended and supplemental declaration. The amended and supplemental declaration says you cannot assess a slip owner except—
Not an assessment, not an assessment. An assessment would pertain to the actual lot and it could be foreclosed as a lien. I mean, as a charge, like a license. I'm selling you the license to use this road and use this property solely for the term of getting easier access to your slip.
Yeah, I don't know if they could charge a licensing fee for that, but I know that they cannot assess, which was the intent of the master.
Oh, yeah, no, every association wants to be able to assess because that gives you the power to impose liens and foreclose on real property. And that's not what I'm talking about.
Well, I think you do have to look at the assessment issue here, though, because they cannot assess, and yet so a slip owner gets the benefit of the Marina Water Walk, that common area that is now in the South Neighborhood that is assessed solely to those South Neighborhood owners. And, their point is, well, that's okay, but it's not, because you're putting an extra burden. If 87.
Ms. Norris, that goes back to the point I was just making, which is no, it doesn't. It does not necessarily prohibit the Southern Neighborhood Association from charging a reasonable fee to use its roads, to use all the things that they pay money for. They just can't assess. They just can't foreclose somebody's unit or house in order to collect that. That's the only difference.
I still think that what you're looking at is basically ignoring the developer intent. I mean, the developer intent was, and it's stated very clearly in the master documents, we're fostering senses of neighborhood communities by giving you exclusive access and assessing you exclusively for them. And then the Marina Declaration, it's because of this exclusive access that we're doing the restriction. The amended supplemental declaration, we're rolling the Marina into the South Neighborhood District. And then the South Neighborhood District Declaration, all of these are created by the developer, and that's the one consistency. And if you read it the way that BKHI is interpreting, then yes, you have no right to assess. You have no enforceable right to assess. Maybe you can charge a licensing fee. You have access to a marina that could not have been permitted under the law at the time if it was intended to serve all of Harbor Island instead of just the community in which it was located. You have the very concerns that the developer expressed in the Marina Declaration: inadequate parking, security issues, access issues. So I don't see how you can read it the way that they want. And the case law is clear that even when a phrase in and of itself might be ambiguous, like the Royal Oaks case, they divided the lot in a way that they thought, oh, well, gotcha, not going to have to pay.
Yeah, it was a clever argument.
Yeah, it was a clever argument. But when you looked at the whole scheme, that argument didn't fly. And that's what Judge Cook was having to do. In order to accept this interpretation, you've got to amend documents, you've got to charge licensing or some type of charge. You've got to figure out how you get access. You've got to figure out what you do about the fact that there's not bathrooms, there's not parking, there's none of the typical amenities that a marina would have to serve this population. And again, I'll go back to the ambiguity, because if there's an ambiguity here, it's the latent one. Every document up through all of these documents shows that the intent was always commercial development in the north and residential development in the south behind the gates. And so the only ambiguity here is now all of a sudden, after these documents, the nature of the north development changes. Now rental apartments become condos. Although under the plain language of these.
So I'm hearing you now saying maybe there was a latent ambiguity. And if that's so, then shouldn't the trial court have convened a trial instead of trying to resolve all of this testimony and all of what the intent was in summary judgment?
Oh, so two things about that. The first is that contrary to what's now been stated, the parole evidence was one way. HEMA, through its president, John Fitzgibbons, had always interpreted this as limiting slip ownership behind the gates. There was an opinion letter that John Fitzgibbons wrote saying, if you look at all the documents together, this is what it means. That's the intent. The residents who testified said that was the intent. That's what they bought for the exclusivity in the neighborhood, et cetera. So all the parole evidence went one way. But more importantly, the judge asked at the hearing, you're both making arguments on summary judgment. Is there anything I need to do to resolve disputed issues of fact? And the answer from both sides was no. So is it
the reason that both sides said no? And this happens a lot when it comes to ambiguity issues, whether it's in contract or is it the reason both sides said no, we're ready to go, is because both sides asserted there's no ambiguity?
I don't think both sides. I think both sides had as one position no ambiguity, but there was also the parole evidence submitted in support of the summary judgment. So there was an additional argument made that the parole evidence also supported this. Both the maps, the plats, the declarations, and the testimony and the opinion letter from HEMA as to how this had been interpreted since developer turnover. So I don't think, the case law is pretty clear. If you're at that hearing and you say, Judge, no, nothing needs to be resolved, you can't go back on and get a reversal saying, oh, well, but if you ruled against me, this does need. I mean, you can make that argument in the trial court. You can say,
well, in the problem though, that the trial judge in rendering her ruling never said I'm finding an ambiguity. So everybody presents their case under the assumption that it's not ambiguous. Yeah, it's not ambiguous. They do, and then the trial court, you present some outside evidence, say, hey, this is part of the context. This is part of the context. The trial court renders a ruling on summary judgment. And even on the order before us, never says there is an ambiguity or I find this to be ambiguous and therefore I must construe it.
And Ms. Norris, I'm going to have you respond to this question because actually my little timer went off. So go ahead and respond to Judge Lucas's question.
Thank you, Judge. Judge Lucas, what I would say is this: both parties argued. Definitely, my client argued if it's either ambiguous or it's either unambiguous in our favor or it's ambiguous and the parole evidence supports us. So that was part of the argument below. If the parties were concerned about what the judge was going to find on ambiguity, they could have asked the judge to make that express ruling. They never did. And again, the judge asked expressly at the end of the hearing. So it's not particularly good practice, at least. And I think the case law says it's a waiver when you answer that question and you say no. No, there is nothing, this is right for summary judgment. So to send it back now, when the party who's asking you to send it back expressly said, no, you can decide it on the materials before you. And I think that's also buttressed by the fact that there wasn't a dispute in the parole evidence. Everybody said this was how it had always been interpreted in the history of the development. So there really wasn't any dispute for the judge to resolve on that either. Thank you, Your Honors.
Thank you, Ms. Norris. Was that sufficient, Judge Lucas? Do you?
Oh, yes, and thank you for allowing her to go over a little bit. I appreciate that.
No problem. All right, Mr. Collins, actually, you have 2 minutes for your rebuttal, sir. And Ms. Norris, excellent, you muted your microphone. Go ahead, Mr.
Okay,
Collins.
thank you, Your Honor, and I apologize. I lost everybody for a couple seconds there. My battery ran out on my computer, so I'm plugged in and reconnected. So I missed a little bit of Ms. Norris's argument. But with the 2 minutes I have, I just want to go back. Basically, the Pelley's argument is, look, this is how SNA has decided to interpret the documents. So therefore, because that's how we've interpreted it, let's lay it over, do a layover, and that's what the developer meant. You see, everything is working backwards in SNA's argument. They're going to 2002 and kind of working their way backwards instead of, as Judge Lucas pointed out, why didn't they just make it clear in 1999? Why didn't they just make it clear in 2002? Why aren't they amending the documents now? Why is it a declaratory judgment injunction? It's because, I don't know, I can only speculate, but I have a feeling it's because someone owns 13 lots and they don't want them grandfathered in. And that would be that's the only thing I can say is why not just make the documents clear? Instead, they're doing this. It's kind of, I like Occam's razor. If you don't need to have a bunch of presumptions, don't have a bunch of presumptions. You'll have a better answer. The developer said anyone who owns a residence on Harbor Island, and then to find different than that, you've got to go through this somewhat tortured analysis of everything that's happened 9 years after that and say, well, the developer clearly knew all of that stuff was going to happen in 9 years. And he just chose not to say the portion that's going to be later defined as a Southern Neighborhood Association. And on the costs and benefits, everything, there is a benefit to having a marina in your backyard. To say that is simply an obligation that's unfair, I don't think many people have a problem having a marina and a seawall in their backyard. As far as the securities involved,
Mr. Collins, I don't know if you've heard my little ringer.
No, I didn't.
All right. I thought it was rather loud, but all right. Well, no, thank you, Mr. Collins, because actually.
Okay, thank you very much. And
right.
We would move for reversal and directions to enter summary judgment on behalf of appellants.
Very good.